Council for giving us the opportunity to be a part of this monumental week where we commemorate refugees, asylum seekers, migrants, and also to open up the window of the day-to-day workings and the day-to-day practice that Farah and I do. And at the start, when Sophie, Farah and I were in conversation, I did say, this might be a bit dense because it's the law, it's boring perhaps for some people might say, but this is what we do. My colleague Farah and I, we are the two immigration solicitors at Hammersmith and Fulham Law Centre. And before I begin, Sophie, are you going to be sharing the PowerPoint slide?
Yeah, that's fine. I'll bring it up now.
Excellent. Thank you. So if we can move to, do I have control, Sophie, or you do? Okay.
No, I don't think you do. I think it's our corporate settings. But yeah, if you just let me know when you want me to move on.
Excellent. So this is a very basic intro to immigration and asylum law to give the audience a flavour of the types of legislation that we deal with on a daily basis. And what we hope is that by the end of this session, you will understand the different immigration applications available. You'll get some information about funding, specifically legal aid funding, public funding, which pays for legal representation for clients with little or no income, and possible support available for clients, and that's financial support as well as legal support. So if we move to the next slide, we'll start by giving a rundown of the types of immigration status, the types of nationalities, the, how can I put it, the profile of the client who might walk into Hammersmith and Fulham Law Centre, and Farah and I will ask questions to understand their nationality and whether they have immigration status, why they're here, so that we can start to unravel and understand the possible routes to staying in the UK. And they might be British nationals who may wish to sponsor a family member, for instance, a spouse or an unmarried partner or a child or an adult dependent. They might be a national of the European Union or the EEA, the European Community, and their family members who may also be European nationals, or they might be third country nationals. And as we know, we are fast approaching the 30th of June deadline for European nationals and their family members to apply to the European Union settlement scheme. And I will be talking about EU rights a little later on in the presentation. Farah and I also deal with asylum claims. We represent a number of unaccompanied asylum-seeking minors who've made perilous journeys to the UK and have asked our government to protect them in the form of refugee status or humanitarian protection. And finally, another route might be discretionary leave, which, as I will explain in a short while, is given at the discretion of the Home Office if the personal circumstances are exceptional, if there are compassionate reasons, And we have specific Home Office policy, which determines when discretionary leave might be granted to a client. The client might come to us and say that they have no status. There are different phrases that are used to describe people who have no leave to remain, no permission, and they might be described as illegal, undocumented, overstayers. And essentially, they are individuals who, as I say, do not have lawful permission to remain in the UK, and worryingly, may become entangled in the government's hostile environment. And what we see in our daily practice is that we do come across overstayers, and part of our job is to advise on potential routes to regularizing status in the UK so that they're able to live, they're able to work, they're able to claim benefits. And when we mean leave to remain, what that is, that means permission to remain in the UK. And generally we find that leave to remain, a visa, permission to remain, lasts for 2.5 years. For instance, if it's based on based on family members, if it's based on private life applications, human rights applications, with which Farah will go on to explain shortly, or leave to remain might be for 5 years. And many refugees and those with humanitarian protection and stateless clients, their leave to remain is for 5 years. And when leave is granted, when the Home Office grants permission for the client to stay in the UK, it might come with a condition of no recourse to public funds. And what that means is that the individual is unable to claim state benefits in the UK public funds in the form of universal credit, income support. And what we found during the pandemic, when people, clients, individuals lost their jobs or were put on furlough and were struggling, is many were subject to no recourse to public funds, and they were able to, there was a route available for them to vary their condition by submitting an application to the Home Office, supplying them with evidence of their finances in the form of bank statements, pay slips, letters from organizations like food banks or charitable organizations, to say to the Home Office, look, you've put a condition on my visa, I'm unable to claim public funds, but I'm in a state of financial hardship, destitution, I'm unable to meet my everyday needs, my basic needs like paying the bills or putting food on the table for my family, or I might be facing homelessness soon. And thankfully, during the pandemic, we saw swift decisions coming through on these types of applications, where the Home Office lifted that condition so that clients who were previously subject to no recourse to public funds, were then able to access public funds. And some client might have indefinite leave to remain, otherwise known as settlement. And what this means is that they can permanently live in the UK without any conditions as to time limits. If you come across a client whose biometric permit says indefinite leave to remain or settlement, what it means is that they are permanently resident in the UK and there is no time limit. They don't need to make another application to extend their indefinite leave to remain. And as we say at the bottom, there's often an overlap because there might be different routes available depending on the client's situation. They might have leave to remain as a partner. They might be in a relationship with a British partner, but if that relationship breaks down, then we might, for instance, look at other circumstances within that relationship. For instance, there might be a child, and so we might want to explore whether there is route available for the client to make an application based on their relationship with the child. And so what Farah and I will do is we will take a detailed case study of the client to understand their profile, social ties in the UK, familial ties in the UK, so we can, like I say, decipher potential routes available to them in the form of immigration applications. Thank you, Sophie. So, no recourse to public funds. There is a Home Office policy document available from the UKVI Gov website, and which can be searched on search engines like Google. And that policy document lists the types of public funds which individuals are unable to claim because they might be subject to no recourse to public funds. And as the slide says, these include well-known welfare benefits, including universal credit, income-based job seekers allowance, income-based employment and support allowance, carers allowance, housing benefits, council tax benefits. Which clients, individuals might be subject to no recourse to public funds? Asylum seekers. So if there are children, child asylum seekers, we would, they might be supported by social services, by the local authority through the Children's Act. They might be care leavers, so looked after under a separate provision, but by the local authority. If they're adults, then asylum seekers should look to asylum support in the form of accommodation and subsistence payments. Undocumented migrants, so those, as I say, are people without immigration status. And most clients with grants of limited leave to remain. And those are the human rights applications I briefly spoke of, based on Article 8 of the Human Rights Act. So family-based, parent, child, private life, if they're making a claim based on their social and cultural ties in the UK. And some EEA nationals, if if they're considered not to have right to reside in the UK. And as I say below, that the no recourse to public funds condition is not permanent and can be removed in some circumstances, depending on the type of leave that they have. And if in doubt, do seek legal advice. So the next slide focuses on European nationals and their families. And there's a dichotomy because we all know Brexit happened. And so you have pre-Brexit and post-Brexit, where the law relating to EU nationals and their family members was domesticated, codified in Appendix EU of the immigration rules. And under the EEA regulations pre-Brexit, EEA nationals were required to exercise treaty rights. So they had to be doing one of the following. They had to be employed or job seeking, self-employed, they had to be studying or self-sufficient. And if they were self-sufficient or a student, they had to have comprehensive sickness insurance. And their family members were defined as either direct family members or extended family members. So direct is when we're looking at the line of descent, so grandparents, parents, and children, whereas extended family members might be aunts, uncles, cousins, siblings, so on and so forth. So we also had derivative rights, which are rights derived from your relationship with an EU national. And you might come across phrases like Zambrano, Chen, Ibrahim, and Teixeira. And those signify different types of relationships which can draw upon derivative rights. So Zambrano, if you're a non-EEA national and you're looking after an EU child, and if you had to leave the UK, if that resulted in the child also having to leave, arguably there is a Zambrano right there. So complex cases and like retained rights, if you have a relationship with an EU national and there's a change of circumstance, you might be able to retain your right even if there's a change in that relationship. So if your spouse passes away, if there's a breakdown of marriage based on domestic abuse, if there's a divorce in that relationship. So if you are finding amongst your service users that you're seeing perhaps an EU element, by all means, contact us. The deadline is fast approaching, 30th of June, and we might be able to offer advice as to what can be done, what kind of application can be made, and we would encourage you to please do get in touch, as we are happy to help, and we have an EU caseworker. Our caseworker is a specialist in EU settlement scheme matters. I think the next slide is to do with the European Union settlement scheme. Yeah, so post-Brexit saw the government introduce a European Union settlement scheme, which gives two forms of status: pre-settled status and settled status. Pre-settled, limited leave to remain; settled status, indefinite leave to remain. And EU nationals and their family members, whether they are EU nationals themselves or third country nationals outside of the European Union and European community, are encouraged or strongly urged and strongly advised to apply by the 30th of June 2021 in order to safeguard their legal position following the deadline. So protection status comes in the form of refugee status and humanitarian protection status. And a typical scenario for us would be if somebody comes to the office and says, I'm from X country, I can't return because my life would be at risk because of X, Y, Z. And they are making a claim for international protection in the UK. They want the government to recognise them as refugees as per the Refugee Convention. And the Home Office, the decision makers, would look to see whether the client, the applicant, satisfies the requirements for refugee status, or if not, if they would then be in a position to satisfy humanitarian protection. And I almost describe it as a pyramid, because when you look at the decisions, or when you look at decision making at the Home Office, they start by considering the asylum claim and move on if the client doesn't satisfy the asylum claim because they don't meet the definition, or if the Home Office argue that, well, they're not a refugee for one reason or another, they should go on to consider whether they satisfy humanitarian protection requirements, whether, for instance, the circumstances are such that their presence in their home country would breach Article 3 of the European Convention, because their life would be at risk. There's a risk of them facing serious harm in the form of unlawful killing, torture, inhumane treatment. They should then go on to consider whether the client fits any of those parameters before moving on to consider the human rights claim. Farah will go on to speak about human rights-based applications, and you can make a separate human rights application based on Article 8, your family, your private life, but the Home Office should also consider a human rights claim discreetly within an asylum claim, within a protection claim. And so that's why we've got that the information at the bottom. An asylum seeker, if granted asylum, will be recognised as a refugee. And the Home Office should also consider humanitarian protection and a human rights claim if the applicant does not satisfy the refugee claim or the humanitarian protection claim. Discretionary leave is, as we say, discretionary. It is essentially the Home Office applying its own policy to see whether the client, the applicant, raises exceptional or compassionate circumstances in their case. And so if they don't fit into any of the other sort of asylum, non-asylum based applications, there might be a reason for them to be granted discretionary leave. Got a couple of examples on the screen. Perhaps the most common that Farah and I would come into contact with would be victims, stroke survivors of trafficking and modern slavery, where the claim can be made separately from an asylum claim or can be made as part of an asylum claim. And the Home Office would say, or the Home Office policy rather says that if an individual is considered to be a victim of trafficking or modern slavery or domestic servitude, they will go on to consider whether that individual should be granted discretionary leave based on their personal circumstances, or if they are pursuing a compensation claim in the UK against their traffickers, or if they are pursuing an investigation with the police. And Farah and I have come across cases where the individual is pursuing a police criminal investigation under the against the traffickers. There might be a criminal date set. They need to give evidence. And so the Home Office, having looked at the evidence, looked at, for instance, evidence from the criminal case, would say you can have a limited period of discretionary leave in line with the policy because you are pursuing a criminal case. So, like I say, that's the most popular, well, the most common type of discretionary leave claim that we do come across. But other cases might be a victim of domestic violence where the client might be given 30 months leave to remain on the basis that they have a British child or British children, or discretionary leave outside of the rules because of the exceptional nature of the case. So that's discretionary leave for you. And I think, Farah, this is for you.
Thank you, Raj, and thank you everyone for staying with us this afternoon. We know you'd all rather be outside in this hot weather, but not much further to go. So yeah, I'll touch upon some of the applications that someone may make based on their human rights under the European Convention. The most common types of application we see are under Article 8 and Article 3. Article 8 would cover family life and private life, and Article would purely be on would be a health claim based on them on maybe medical treatment that they're undergoing in the UK. Now, examples of an Article 8 a family life claim would be where a parent would be making an application based on a child, where their child is born in the UK and has been in the UK for 7 years, and it would be unreasonable for that child to leave and go to the country of origin of the parent because the child has been here for 7 years, spent their prime years in the UK and have settled in the UK. Another example of family life could be based on a partner, where their partner is British or settled or has refugee status, and that there'll be unsurmountable obstacles for their partner to leave the UK and join them in their country of origin. And these two applications are the most common types of application that we get under the family life route. The other types of application would be a private life application, depending on how long you've been in the UK. Most commonly at the moment, we're seeing a lot of homeless clients making applications under the 20-year rule. This is a discretionary application where a client can argue that they've been in the UK for 20 years and they don't have to have valid leave in the UK. It just has to be continuous 20 years, but the onus is on the client to show the evidence that they have been in the UK. Or you could show that there are very significant obstacles to returning or integrating in their country of origin. So an Article 3 application, like I said earlier, would be a medical case, but the threshold is very high here. You would need medical reports, GP letters, hospital discharge letters, maybe even independent reports showing that that person cannot get the treatment that they require in their country of origin, or that they are not fit to travel abroad. And often there's a combination between Article and Article 3 cases. However, if you're applying for an Article 3 application online, you cannot mix Article 8 into that. But if you are making an Article 8 application, you could submit some kind of Article 3 representations within that as well. Now, often human rights-based applications are not covered under legal help funding. So what is in scope under legal help funding? The most common are asylum cases, detention and bail, some non-asylum immigration, such as applications under the SET-DV, the domestic violence rule, and applications for leave to enter or remain in the UK by victims of human trafficking, and some other special immigration appeals commission proceedings, and some onwards appeals at a point of law to the Court of Appeal and Supreme Court. Now, often people remain without leave in the UK because they feel I cannot afford to make an application, and I cannot afford representation, and then they go under the radar. They don't contact the Home Office, and often are detained or liable for deportation. And it's very important to know that legal aid providers can apply for something called exceptional case funding, or ECF funding, as we call it in short. And we can apply to the legal aid agency arguing that this application is very important to the client and that the client is destitute. And 9 out of 10, the application is successful for ECF funding. And yeah, again, you must show that there's significant importance to the application. And once ECF is granted, we can also apply for something called a fee waiver. So most Home Office applications have a fee, but we can apply for a fee waiver, which is quite easy to obtain once you've got the ECF funding in place. Now we'll move on to trafficking next. Raj touched upon this a little earlier. So this is called the NRM referral process, where if you suspect somebody of being a victim of trafficking or modern slavery, there's quite often a route you have to follow. The first thing is to refer them to the national referral mechanism via first responder. A first responder could be the police, the UK Border Force, UK Visas and Immigration, the Home Office, or most often we contact the Home Office or the Salvation Army. And this can be done via email or by phone. And it's a kind of a 3-step process where you would initially get a first decision, which is called a reasonable grounds decision, where you could be suspected to be a victim of trafficking. Then within 45 days after that, you should receive something called a positive decision, and you would get a 45-day reflection period and access to financial and psychological support and accommodation. Now, often they say 45 days, but Raj and I know this hasn't really been the case lately. However, we have argued to speed these cases up. Following from there, you would get something, the second stage of the decision, whereby it would call the Home Office call it a conclusive grounds decision, where have you been a victim of trafficking or modern slavery, yes or no? And if you receive a positive decision, thereafter you would be able to apply for discretionary leave, as Raj touched upon earlier. Most often victims of trafficking and modern slavery don't even know that they are victims, and it's sometimes up to us to kind of look out for these red flags. And many of our clients who are victims, we've noticed they're fearful of the police or authorities. They're generally not trusting of authority figures. They exhibit signs of physical and psychological trauma. They're usually very anxious. They often forget a lot of what they have been through. Some of them may even have been physically abused and have scars. And many of them have been forced to work abroad whilst on their journey to the UK. However, the victim may think they have been paid for this, even if they've been paid, the very bare minimum. They would think that's payment, whereas they would be classified as a victim of trafficking. They would have historic limited freedom of movement, including medical care, a social life. They would have, like I mentioned, they'd be unpaid or paid very little, and may often be paid late and not the amount that was initially agreed upon. Most often, a lot of them seem to be in debt to somebody. They may owe money to an agent who brought them to the UK. They do not have a passport, and sometimes mention that an agent or their employer is holding their passport, which should not be the case. And sometimes we find that a lot of them fear being controlled by witchcraft, or they're threatened by witchcraft. So these are all indicators to look out for. Raj touched upon the asylum process earlier on. So with the NRM, the asylum process has kind of a systematic approach as well. So the client should initially claim asylum as soon as possible. They should not delay claiming asylum, and there is a number to register their claim over the phone. They would be given an appointment, which is called a screening interview. This is a very short interview where they'd be asked their basic questions, their personal details, and very, very brief reasons as to why they are claiming asylum. They would most often at that appointment be given something called an ARC card, which can be used as their initial ID, because a lot of asylum clients do not have any form of ID. Thereafter, they would have something called a substantive asylum interview. This is usually an in-depth, a long interview where the client would go in detail about their interview, and they should always be given a record of their interview, either on paper or on a USB, so that after the interview, the the person representing them can go through the interview with them to make sure all the details are correct, and then we would have 5 working days to submit any documentary evidence or corrections to their answers. Thereafter, we should get a decision, and the outcomes would be they're either granted leave, they're either refused, and often they are refused where they're granted a right of appeal or no right of appeal at all. And again, all these decisions can be challenged depending on the nature of the decision. Some important things to understand in the asylum process, that a negative decision without a right of appeal, again, can be challenged, but it must be referred to a solicitor within 3 months for further advice to challenge it by way of judicial review. A right of appeal must be referred to solicitor for further advice within 14 days of the date it was sent out. Now, many people think it's the date they receive it, but we go by the date it was sent out. A delay of more than 1 year in receiving a decision should be referred to solicitors to challenge the delay, or sooner, depending on the client's personal circumstances. If a client is waiting for more than a year for a decision, which we have found is the case lately, you can ask the Home Office to use their discretion and ask their permission for your client to work, because a lot of them, although receiving NAS, they want to work. They don't want to be reliant on NAS. And most often the Home Office do grant permission to work if there has been a substantial delay. So asylum support, also known as NAS, who is eligible? Destitute asylum seekers, destitute failed asylum seekers, and asylum support will cover some kind of accommodation and provision of financial support to meet their essential living needs. So there are 2 types of NAS support. There's Section 95 support, which is for first-time asylum seekers where the asylum claim has not yet been refused. And then you have Section 4, where the provision allows for support to refuse asylum seekers. So these are for clients who have just submitted a fresh asylum claim, who have fresh evidence for their claim. Some clients could apply for something called community care support under the Care Act if they have substantial care needs. So could be physical impairments, mental impairments, where they have problems day-to-day living with eating, sharing, managing money, etc. If they're minors, they could get support from social services under the Section 17 Children's Act. And if their condition is very severe, under Section 117, the aftercare support. Sometimes we get clients who don't want to make any kind of application, and this is more common than people think. A lot of clients, they've been here for a while and they just want to go back, and this is called voluntary return. And if they do wish to go back to their home country, they may also be eligible for some kind of monetary assistance, and this would depend on individual circumstances as to if and how much they would get. Now, obviously no application runs smoothly, and there are some potential difficulties with all the applications that Raj and I have mentioned. Now the burden of proof is on the applicant to try and find all this information, and often especially with homeless clients, they do not have these documentary evidence, and some applications have a very, very high threshold, such as the medical application I mentioned earlier under Article 3. Sometimes the Home Office may request original evidence, and this is not always possible, especially for a client claiming asylum, for example, where they have no contact in their country of origin, or they're too scared to contact in their country of origin. A lot of these clients don't have ID, they have lack of records despite long presence in the UK, and often some of them even have criminal records, which does go against them in their cases. So how can we help, and how can you support these clients? Well, we can assist in obtaining these evidence. So we often rely on third parties to assist us, such as the GP records, or maybe religious places of worship where the clients attend regularly, witness statements from friends, from family, from support workers. And what type of documents might be useful for clients in any kind of applications would be, we can obtain their medical records, their NHS records, we can obtain GP records, we can obtain something called a subject access request from the Home Office, which is free, to see what their immigration history is, because a lot of clients, they've been here for many years and they don't know the dates they arrived in the UK, they don't know what applications they have made or what legal representations have made them on their behalf. So a starting point would be to get a subject access request first, to see the history of the client, the immigration history of the client. You could try and obtain bank statements if the client has a bank statement, and again, letters of support from anyone in any organization involved the client, any charities, places of religious worship, the council, or any volunteers that are assisting their client. So I know that was a lot of information overload this afternoon from Raj and I, but we hope you've managed to take something from our talk today. But please feel free if anybody has any questions.
I've got one here. I'm a non-EU citizen, and I'd like to know, what is the term of ancestry? Hello.
Hi, Ben. Thank you for your question. The ancestry route is for individuals who are relying on their grandparents' British roots to claim that they are also British. It's not an application which I don't think I've ever come across at the law centre, but you would need to show that the applicant can draw their relationship back to a grandparent who is British. So they would need to show the grandparent's British passport and the applicant's parents' birth certificate to show that the grandparent gave birth to them, and subsequently the applicant would need to show their own birth certificate to show that their parent is their parent.
Another one, yeah. You said something about overlap, like different routes possible. What does that really entail?
So often we find, for example, if a client is a victim of domestic violence, they could also rely on an application based on a British child, or somebody may have a private route life, but also have medical issues as well that they want to argue, which can be done in the same application most often.
So the same person of a victim of domestic abuse, which, like, you're not an EU citizen or not an yeah, non-EU citizen, but you're say for instance they are married to a British partner and they succumb to that domestic violence. What does the Home Office really do about that?
So Farah and I, we have a partnership with a domestic violence agency known as Southall Black Sisters, who are based in Southall in the borough of Ealing. And they often refer cases to us. And to give you a typical scenario, Ben, we might have a client who is the spouse of a British national, so who came in who was given permission as the spouse of a British national. And during the course of that relationship, during the course of that visa's validity, the client has suffered domestic abuse. And under the immigration rules, there is a specific route for individuals who are married to British spouses, where they can make an application based on domestic abuse, and if successful, they would be granted indefinite leave to remain. But that same client might also say, if I am returned to X country, I would be disowned by my family, I would be ostracized by my family, I would be ostracized by wider society, therefore my life is at risk if I return. So we would advise the client that they have two potential avenues: one, to make an immigration-based application under the domestic abuse provisions of the immigration rules, or to claim asylum if they fear persecution or harm upon return. So that's what we mean by overlapping routes in the UK.
Okay, well, you made a question there, as in it only apply. It seemed like the answer you gave me only applies to ladies. It so like in a sense, that applies to both man and woman, as in a sense.
It does, and I've had many successful male applicants who have been granted indefinite leave. I mean, domestic violence, it's not, it can affect anybody. It doesn't matter if you're female or male. There are many male applicants as well who have suffered quite severe domestic abuse, and it's not limited to physical abuse. The types of domestic violence can include emotional, it can, financial abuse, and it could also include some kind of verbal abuse, even from the in-laws. It doesn't have to be directly from the partner. So it's not just limited to female, and many male applicants have been successful.
Okay, you also said something about section 4, bracket 4, where it's a destitute fail asylum act. Yeah. I don't what really is that about? Because like I know people who are gone for asylum, failed, appealed, gone for it again, and they failed. In a sense, whereas to me the Home Office is just doing it as a stamp, look at your paper on a stamp basis. And it's because I think they say it's like what tier you're in or something like that. So what does the destitute fail asylum act, does that really work?
Yes, we are working with the Greater London Authority presently and assisting a number of homeless clients with their immigration status. And we know of clients who have successfully applied for asylum support in the form of subsistence payments and or accommodation through this mechanism, and they then go on to be accommodated because they are destitute. They've provided evidence of their lack of finances, and the Home Office have made an assessment and go on to provide that form of support.
Okay, so as the Home Office back them up as to say, instead of giving them that support, giving them the opportunity to live and work in this country?
If there is an application pending,
Mhm.
then you can make that argument that, you know, the delay is not the client's fault. However, if the client does not have an application pending, then it is very difficult to request for permission to work, from my experience anyway. I don't know about you, Raj.
Yes, and for asylum seekers who want to request permission to work, the Home Office have a shortage occupation list, and through their request, they should explain to the Home Office which employment from that shortage occupation list they are likely to take up. So they should show qualifications, skills, experience.
Okay. The next question though. And just a quick question, where are you guys based as well?
We are based first floor Hammersmith Library.
So right now we are working remotely, but it's business as usual. You know, we're taking queries, we're signing on clients as per usual.
Okay, and what days are you? What do you guys have a phone number or something like that?
We do. It's on our website. If you do have a query, more than welcome to give us a call, and reception will direct you to us.
Okay, thank you very much, Miss.
Thank you, Ben.
Thank you for that. That was really helpful. If anyone else has any questions, please feel free to shout them out, or you can type them in the chat, and we will we'll get back to you on that. I just had a very quick question. So you mentioned earlier that if a case has been submitted but has taken, say, over a year and they've not had a response, the claimant's not had a response, that the claimant could apply for the right to work. Is that correct?
Yeah, so it's set out in the Home Office's permission to work policy, and there must be an asylum claim, and there must be a delay of at least a year, and that delay essentially has to be, well, not the client's fault. So what we find, there are processing delays or delays in scheduling interviews by the Home Office, and a year goes by. In order for the client to apply for permission to work, they should look at the shortage occupation list, which is available under the immigration rules, and that sets out the types of employment that they can take up. So it's restricted employment.
Right. Okay.
Is what the key word is restricted to the shortage occupation list. We have, I believe, nurses. I think chefs are also on the shortage occupation list. And to give you an example, a couple of months ago, we successfully obtained permission to work for an asylum seeker who is a pediatric surgeon in their home country. And as part of that application, we submitted their CV and their degrees, publications, so on and so forth. The Home Office made an assessment, looked at the shortage occupation list, and granted that individual permission to work in the UK. And Farah's just circulated our contact details in the chat.
Great, thank you. The other final question that I have, but anyone else, please feel free to jump in, was once an asylum case has been lodged, Is the claimant then eligible for NAS accommodation from that point, or do they have to wait? We've had cases of, you know, people waiting and waiting, and they've submitted their claim and are still not able to access accommodation.
I think it's important to note that you have to inform the Home Office at your screening interview that you are destitute. A lot of clients feel that once they claim asylum, they're automatically registered to obtain NAS, and that's not the case. You have to let the Home Office know that you are destitute, you need accommodation. So most often, if you let them know even at the point where you're claiming asylum, registering your claim, or at the screening interview, you're granted NAS support quite soon after that.
Right, okay. That's really good.
Otherwise, the Home Office will assume that you have a place to stay.
Yeah, yeah. No, that makes sense. Are there any final questions from anyone else before we close the session? If you do think of anything after the session, you can go back and watch the session again. It's on our YouTube channel, but please do get in touch and I'll make sure that your questions are passed on. But I just wanted to say a massive thank you to the Hammersmith and Fulham Law Centre, to Raj and to Farah, for presenting and for answering your questions. And I hope it's been really informative and really useful, and very, very relevant, I guess, with everything that is coming up in the next few weeks, and with our theme of Refugee Week and supporting refugees. So thank you very much for coming along. It's been really great.
Thank you, Sophie, for facilitating the session.
No problem. And thank you to everyone else for attending. Much appreciated. Enjoy the sun.
Thank you, everyone. Bye.
Thank you, everyone.